Now the other issue is how candidates raise money. Some people have breathed a sigh of relief about this year's race. Yet I see a lot about the 2009 race that ought to trouble us greatly. First of all, let's start with the incumbent Chief Justice. She went out and raised over $1 million. She did it undoubtedly to try to inoculate herself against the very kinds of things that happened in the last two races. She didn't want done to her what was done in the past race, where 90% of the TV ads are done by a few interest groups and she gets pushed to the sidelines. So I don't blame her a bit. However, all those campaign donations will have implications, and they will come back to bite her if re-elected. Because if she continues to serve on the court, inevitably there will be cases that come before her, and some of the people who stand before her will be major campaign contributors, and there will be claims that there are conflicts of interest, and there will be demands that she recuse herself and not hear those cases and not rule on those cases. So the winner's ability to serve as a justice, the winner in these elections, that person's ability to do the job in a way that has the public's trust is jeopardized by the way we conduct these elections. And it will taint the incumbent Chief Justice if she's re-elected. So that's something that ought to continue to trouble us, even if we don't see the kind of hijacking in this race that we saw. Now let's talk about the challenger in this race. For the life of me, I can't tell the difference between Randy Koshnick and Mike Gableman. Look at the two of them. They both grew up in the Milwaukee area, in the Milwaukee suburbs. They both went on to become circuit court judges in small rural counties. They both graduated from the same doggone law school, by the way. They have almost identical physical builds. They have virtually indistinguishable judicial philosophies, and their stated reasons for wanting to be on the court there doesn't appear to be a difference there either. The interesting thing is, if you watch them campaign, and you actually watch them out on the stump, Koshnick is actually the much more polished and capable campaigner. Yet Mike Gableman is sitting on the Supreme Court, and Randy Koshnick doesn't appear to stand a chance. Now what's the difference? The only thing I can see is that Justice Gableman had 3 interest groups and $2.7 million of their money behind him, and Randy Koshnick so far has been denied that kind of assistance. That, to me, is an extremely troubling sign that a candidate's viability today has everything to do with their ability to line up major interest group support. So I'm not breathing the sigh of relief that many others are about how this 2009 race is playing out. There is still all the markings of a dysfunctional system that needs to be repaired. If we are to have, first of all, contested elections where people have a real choice and can hear from candidates. We're not hearing from both candidates in this race. We're not seeing campaign advertising from both candidates. And then we need a system where the winner is able to serve as a justice without the public constantly doubting whether they have financial conflicts of interest, whether they are in fact being driven in their decisions by their campaign contributors and special interest influence. So I think first we need to free the candidates from the money chase. We need to give candidates the resources to reach voters and get a message out to the public without compromising their ability to serve as a good judge once elected. And we need all the candidates to be heard from. And then secondly, we need to make sure that the interest groups are operating inside the law and not outside the law so that they can't hijack campaigns. We can't tell them that they have no place in elections, and we wouldn't want to. But what we can insist upon is that they disclose their sources of funding, that they let us know who's really writing the checks and who's really sponsoring these messages, so that we know who they are, who's behind them, how much money they're spending, and where that money's coming from. And we can insist that they follow the same disclosure requirements and the same campaign contribution limitations that candidates follow. Now, the U.S. Supreme Court has twice now ruled in cases on whether this kind of disclosure is constitutional. The U.S. Supreme Court has had 2 opportunities to strike this kind of disclosure down as unconstitutional, and twice now In McConnell versus FEC and Wisconsin Right to Life versus FEC, the U.S. Supreme Court has declined to strike it down as unconstitutional. They have said that disclosure of this kind of interest group spending is permissible. They have left that door open. They have said that there's a need to distinguish between the functional equivalent of electioneering and grassroots lobbying, simply an attempt to influence legislation or legislative decisions. But they have said that if it's the functional equivalent of a campaign ad, that can be regulated and it can be subject to these disclosure requirements. And so we have a very conservative U.S. Supreme Court, which has twice ruled that this kind of measure is permissible. It was mentioned that our State Government Accountability Board has already approved a rule, and that is true. The Government Accountability Board actually used the language of Justice Roberts, used a test that he spelled out in his latest Supreme Court decision in fashioning that rule, making it as constitutionally bulletproof as you could possibly make it. That rule is now before the legislature as of today. But there's also legislation that's been introduced. The Impartial Justice Bill is Senate Bill 40 and Assembly Bill 65. The Issue Ad Disclosure Bill, the Special Interest Electioneering Disclosure Measure, is Senate Bill 43 and Assembly Bill 63. Those two measures are before the legislature, and I think if those things are done in combination, we can have candidates that matter, that are actually heard from, and we can have elections where voters get information from a diversity of sources without any one source or without any one group or four groups so dominating the discourse, so dominating the campaigning that literally no other voices are heard. So that's what I think we should focus on, is fixing these elections, getting back to the point where we no longer have auctions, but we again have elections, and doing it in a way so that the candidates matter again and special interests don't own our Supreme Court elections.